Good afternoon. My name is Emily Sumner with Sumner Immigration Law, and I'm glad that you've joined us for this webinar on the H1B Cap season for this year, 2022. It's actually for fiscal year 2023. We will go ahead and get started, and others can join in as they're able. Just as an announcement, we are recording this presentation, and we will be emailing it to everyone who has registered for the webinar. So what we're going to be talking about today. First, what is an H1B visa? Secondly, the overview of the H1B Cap registration process. Then information about status-specific considerations. So if you have an employee who is in a specific status, we'll be talking about specific considerations for them, timelines, and next steps. As a reminder, this information, this webinar is for educational purposes only. It is not legal advice. I'm not able to give legal advice through a webinar like this. If you have specific questions, of course, reach out to us and we're happy to help, but this is not legal advice. In addition, I would love for this to be an interactive experience. So feel free to put your questions in the chat. I'll be keeping an eye on that as we move along, or unmute yourself and ask. That's totally fine as well. So what is the H1B visa? This webinar is designed for employers who are interested in sponsoring employees for the H1B classification for the first time. If you are not an employer, if you are an employee or somebody who's thinking about registering for the H1B, welcome. We're happy to have you. But just as a heads up, this will be geared more towards employers. So what is an H1B visa? Who is eligible for an H1B? What is the H1B cap? And why did the government change the H1B process? That's what we'll be talking about first. So for almost every letter of the alphabet, there's a different visa classification, and there are different subclassifications within those classifications. The H1B visa is a specific type of non-immigrant visa, meaning a temporary visa, that is available for up to 6 years for foreign nationals working for US employers, meaning employers in the United States. The employee, the H1B employee, has to be working in a position that's called specialty occupation. That means that the position and the occupation in general needs to be one that generally requires a minimum of a bachelor's degree in a specific field of study. And then finally, there is an annual cap in for the H1Bs, new H1Bs every year. That cap or annual limitation on new H1Bs is 65,000, kind of regular is what we call them, regular H1Bs, and then an additional 20,000 for US master's degree holders, US master's degree or higher. Just to go back for a minute to the specialty occupation definition, there is, for some visa classifications, for example, the TN, there's a list of very specific occupations that are eligible for that particular visa classification. That's not true for the H1B, meaning we have some leeway. We have some room for, I don't want to call it creativity because everything has to be accurate that we submit, but there is room for occupations that maybe are not well known or that are not specifically listed in the Department of Labor database. So if you have an occupation that is less well known, then know that it is still possible to file. If it's a position that we can make an argument accurately that the position requires the minimum of a bachelor's degree in a specific field of study. So note that it's not enough to have just a bachelor's degree. We're looking at whether the position requires a bachelor's degree in a specific field of study and whether the H1B employee or prospective employee has that bachelor's degree. So for example, within my law firm, I generally require that paralegals have a bachelor's degree, but I don't require that they be in a specific field of study. That bachelor's degree can be in basically anything. I just want paralegals who have been to university who have that analytical, critical thinking ability. So that would not classify as an H1B. But if you're filing for something like a civil engineer, which is a very cut and dry example, but a civil engineer obviously requires a bachelor's degree in civil engineering in order to hold that occupation. So again, we're looking at whether the position requires a minimum of a bachelor's degree, and does the individual employee have that? So who defines this? Who determines whether a position requires a minimum of a bachelor's degree in a specific occupation? USCIS tends to look to the Occupational Outlook Handbook. That is a publication, it's available online, but it's a database published by the Department of Labor. And they have different classifications or different occupational classifications, and they have lots of information about that occupation, including what the Department of Labor thinks is required for as a minimum to enter that particular occupation. And remember, we're talking about the minimum requirement for entry into the occupation. We're not talking about the ideal. We're not talking about preferred, or what a person might have 10 or 15 years into their career. We're talking about what's the minimum to enter that particular occupation. So the OOH, like I said, is published by Department of Labor. They publish what they think. And so that can be a good source. You know, whenever we're doing analysis for whether a position requires a degree, a bachelor's degree at least, in a specific field of study, we always look at the OOH to see what it says. Sometimes the OOH will be on our side. It'll have a very clear entry and say a minimum of X degrees required. Our client candidate has that, we're good to go. In other situations, the OOH either has an entry, but it's not very clear. It will say something like it's sometimes preferred, or it won't have a specific degree field. Or other times there's just not an entry for that particular occupation in the OOH. We see that a lot in the pharmaceutical development or clinical research fields and other fields as well. That's okay. Even though it's not in the OOH, we still can make arguments. And that's part of the analysis that we do when we first begin a case. And then to the question of whether the individual employee, the prospective H1B employee, has a bachelor's degree in a specific field of study, obviously, the cleanest case is if they have a US bachelor's degree in that particular field of study. That's great. But there are other situations that are just as acceptable as well. So for example, if the foreign national has a foreign bachelor's degree and we can get a credentials evaluation, and that's something that our office can help you coordinate. But if we can get a credentials evaluation saying it's equivalent to a US degree, that can work. In addition, a person can have a combination of education and experience to be equivalent to a bachelor's degree in a specific field of study. Again, that's something that we help our clients with all the time, and we can certainly help out with. So what is the H1B cap? The H1B cap is the annual limit on the number of new H1B petitions available every year. The annual cap, and this is in the statute, so it's not something that's easily changed, but the annual cap is 65,000 H1B petitions, or slots, if you will, available every year, plus an additional 20,000 for US master's degree holders or higher. Remember, that has to be a US master's degree. It can't be a foreign degree. In addition, the university, if you're going to qualify under or try to qualify under the US master's degree allocation, the US master's degree has to be from a school that is accredited, and it has to be a school that is not for profit. So if it's a for-profit school and or not accredited, unfortunately, the person is not going to qualify under the US master's degree cap. And that's, again, something that we look at carefully when we're doing the initial analysis with a new H1B candidate. The other thing to keep in mind for the H1B cap is it applies to new H1Bs only. So if you have, as an employer, have a situation where you have this person who says, hey, I am on X status, let's say they're on H4 status or F1 or some other immigration status in the United States, or even if they're located overseas, one of the first questions that we ask is, have you ever been counted against the H1B cap before? Because if they have, then they likely would not have to be counted again, and they could file an H1B petition. There are other things that we need to look at in that particular situation, but that's the number one thing. It seems like every year we find at least one person who has been counted against the cap before, and they don't have to go through this registration process, which is great. So the other thing to consider is the H1B cap does not apply to H1B transfers, extensions, or amendments. So in other words, if a foreign national is in the United States in valid H1B status now, and they're transferring from company A to company B, or if they need to extend their status with the same company or amend, if they have a change in where they're working or a change in salary, significant change in salary, then they're not subject to the cap. We can file the extension or amendment, whatever it is, and it's not an issue. The final thing to be aware of in terms of the H1B cap is that it does not apply to every employer. There are very specific exemptions. So for example, institutions of higher education, universities, the universities are not subject to the H1B cap. They can hire a professor or researcher or basically anyone who would otherwise qualify for an H1B, and they're not subject to the H1B cap. Likewise, there are certain very narrow exemptions for organizations, for example, certain nonprofit organizations that have a connection with these institutions of higher education. So that's something to look at. You don't want to just assume that the H1B cap is the way to go. Most of the time, for most of the clients that we work with, the H1B cap is required. So why did the government change the H1B cap process? If you are new to this process, you probably don't know that it has changed, but it has tremendously. So in 2020, that was obviously a year of tremendous change for lots and lots of reasons. But in the year 2020, USCIS started this new process for the first time. It used to be, prior to 2020, that if an employer wanted to file an H1B cap petition, we would prepare the entire petition. So we would file the labor condition application, which is one of the documents, the forms that we have to have. We would file that. We would prepare all of the forms, the support letter, all of the supporting documentation, prepare everything, and file a petition as if it were going to be accepted by USCIS. So we would file that petition April 1st, or the first business day of April. Then USCIS would review receive all of the petitions. Typically, we had 5 business days to file all of the H1B cap subject petitions. So we would file those with USCIS, and then typically since the year, I think 2011 or 2012, I think 2012, they received more petitions than they had slots available for, and so they would conduct a lottery. In order to conduct that lottery, they would take specific data from all of the cases that everybody had submitted and conduct a random lottery. They would first select the 20,000 US master's degree cases, and then select an additional 65,000 regular cases. Then the process changed, the regulation changed. And it actually, I think, makes a lot more sense the way that they're doing it now. The reason that they changed is, and we'll explain with the new process, that it's not really new anymore, but relatively new. But we'll talk in a minute about what the new process is. But the reason that they made this change is for cost savings and efficiencies, both for you, the clients, and for USCIS. So you no longer have to pay the legal fee to have, or the filing fees, although they didn't take those unless the case was selected, but you don't have to pay the filing fee and submit, a stack of paper this tall, or the attorney didn't, for a case that was just going to be rejected because it wasn't selected in the lottery. Efficiencies, obviously, the way that it's done now is much more efficient, both for USCIS and for us and for our clients. And it was done to further USCIS's goal of modernization and moving away from a paper-based to an online filing agency. I will say we still file that by paper. There are very few classifications or types of visas that we can file, petitions that we can file online, and the system can be quirky, is a nice way to put it. But they're moving towards that, at a government pace, they're moving towards modernization. But this is a nice way to, like I said, save time and money for everybody involved in the process. There are disadvantages that we'll talk about in a minute. So what does this new, quote unquote, new H1B cap process look like? There is electronic pre-registration, which we'll talk about in a minute. Then USCIS will conduct the lottery, and then we'll talk about what information is required. So this registration process or pre-registration process, means that employers will register beneficiaries for the H1B Cap lottery online. There's a specific registration period, which USCIS just announced for this year. This year, it begins at noon on March 1st, and it ends at noon on March 18th. And that's noon Eastern. The registrations are employee and employer specific. So when an employer registers online, they will, and we can do this for an employer, but we will register using very specific information, but it's a lot more streamlined of a process. So we're not submitting all of the, we're not drafting an LCA, a labor condition application. We could, but we generally don't do that until we know the case is selected. So we just submit very streamlined information so that USCIS can conduct the lottery. There is a $10 USCIS registration fee. In our practice, we actually include that in the legal fee for the registration and the analysis and all of that, so you don't have to pay that separately. So when employers register, or we register employers for them, USCIS, and we'll talk in a minute about what specific documentation or information rather is required for that. At the end of the registration period, USCIS will randomly select registrations that they properly received during the registration period. The random selection is done on or before March 31st. So in the past couple of years, like I said, this has been in place since 2020. In the past couple of years, we started receiving notifications the end of March, before March 31st, I would say like March 26th or so. The last week of March, we started receiving registration notifications, and it's not done all at once. You would think that the system would just email all at once, but for whatever reason, that doesn't happen. The notifications kind of trickle in over about a week or so. By early April, I would say the first week of April, we should have all of the notifications, and USCIS typically makes an announcement saying that everybody who has been selected in this round has been notified. So it's a relatively fast process where you'll know that the case has been selected or not. Once you receive notification that the case has been selected in the lottery, the petitioner has 90 days to file the petition with USCIS. So it's at that point, once we know the case is selected, that we are filing the full H1B petition with the LCA and all the forms and all the supporting documentation. And you all feel free to ask questions as you have them. So the lottery process has changed a bit as well from the before times, if you will, before COVID and before, though COVID doesn't affect this, but before they implemented this new registration system. So it used to be that before, when we submitted the whole package of forms and everything, USCIS would select the US master's degree petitions, and then they would select the 65,000. If you weren't selected in a master's degree selection, you were put into the regular pool with everybody else. With this new registration process, USCIS actually flipped that process around. So now they will put everybody, US master's degree holders and everybody else, in a big pool and select 65,000 petitions from there. Then if a case is for a US master's degree holder, they'll run another round, another lottery, and select 20,000 US master's degree cases. We don't know, it's not, they don't send notifications saying, hey, you've been selected in the lottery, and then they send another set of emails for US master's degree cases. We know which lottery a case was selected in because it will say that on the selection notification letter. But if you receive, in other words, once USCIS announces in early April that the selection process is completed, at least for now, and we'll talk about that in a minute, but once they let us know that that's completed, then that's it. It's not like we need to be on the edge of our seats waiting to see if a case will be selected in the US master's degree round. It is possible very possible that there would be another round of selections. And this happened the past 2 years, it happened, meaning if USCIS will notify everyone, like I said, that everybody who's selected in the lottery, they'll notify us. we have 90 days to file that petition. Then in around July of this year, and this has happened in the past couple of years, USCIS will assess how many petitions they've received. If they have not received enough petitions to meet that statutory allotment, the 65,000 plus the 20,000, they will make another round of selections. And so we may get an email, let's say that you're not selected at the end of March, early April, we may get an email in July saying your case has been selected. And again, USCIS makes announcements about that. We let our clients know, we put it on social media, email newsletters, that type of thing. But if your employee or you are not selected in the first round, keep the faith. There's not a high possibility, a high probability that you would be selected, but it is possible that you would be selected in July. This year, for the first time ever, we actually had a third round of selections, and we were notified in November of additional cases, and we're actually about to file our last H1B Cap case actually today for last year's lottery that happened approximately a year ago. So it is possible that your case would be selected, and we'll talk in a few minutes about the reason that I think that that we know that that's happening. But know that, I wouldn't hang your hat on that. The likelihood of that happening is pretty small, statistically speaking, but it is possible. We'll talk about statistics in just a minute and your chance of being selected in the lottery. So what's required to register for the H1B? Let's say you have an employee, you want to register on the H1B lottery. What is required from the employer side? This is the basic information that's required from the employer. It's pretty streamlined. We would need the employer's legal name, their DBA, if that's applicable, tax identification number, their primary address, and then the name of the person who's going to sign the forms and their contact information. From the beneficiary, so this is the employee, we would need this information: their name, their gender, whether they have a master's degree or higher, and that's really important for the reasons I talked about a minute ago, because that will determine if they are put into the U.S. master's degree lottery, if they qualify, their date of birth, country of citizenship, which may be different from country of birth, and then their passport number. So again, this registration process is employee specific, unfortunately, or maybe fortunately for policy reasons, but it is what it is. An employer cannot just say, hey, I'm going to put in 10 registrations this year and see what happens, and then I'll find some people to fill those slots. No, it has to be specific to this particular beneficiary. And likewise, you can't say, well, Joe, I registered for John Smith and he was selected, but he decided to go back home or to go with another employer or whatever the case is. So I want to substitute Jane Doe. That's not possible. It has to be for the specific employee that you registered and that was selected. So we're moving now to case specific or status specific rather information or considerations rather. So we mentioned this previously, that if a person, one of the first questions we ask has the person that you're considering registering, have they ever been counted against the H1B cap before? Because if they have, they may not need to be registered. We may be able to just file an H1B petition for them and not register in the H1B lottery. That's always a happy find, though pretty infrequent, but you never know. So other statuses, or stati maybe is the right word, that you need to consider is, what if your employee is on OPT right now? That OPT stands for optional practical training. So when a person studies in the United States on an F1 visa, the student visa, when they graduate, they will be given 12 months of OPT, optional practical training. So you may have hired someone who has OPT and it's valid for up to 12 months, and then they may qualify for a STEM extension, meaning if their field of study is on a specific list in the fields of science, technology, engineering, or math, they may qualify for an additional 24-month extension. Regardless of whether your employee is on the first 12 months of OPT or a STEM extension OPT, they could qualify for what's called the H1B cap gap. So this refers to the situation when, let's say that the OPT, for example, Your employee's OPT is going to end July 1st of 2022. You register them in the lottery, they're selected for the lottery. That's awesome. Everybody's so excited. So then the question is, well, wait, what happens between the end of their OPT and the October 1st start date? By regulation, by law, the start date, earliest possible start date for an H1B, for a new H1B, is October 1st of that particular year. That's when the fiscal year starts, and H1B status for a new H1B petition cannot be effective before that date. So what happens then between 7/1, using that as an example, and 10/1, H1B cap gap is what happens. So in this particular situation, and again, this is something that we look at in our analysis, and we look at when candidates are selected for the H1B registration for the lottery, but it is only for individuals, F1 individuals who are on OPT. So if you have an employee who is on CPT, curricular practical training, and we'll talk about that in a minute, they're not eligible for the cap gap. It's only for individuals on CPT. The individual has to request a change of status. They cannot select consular processing. They have to select a change of status. We'll talk about travel in a minute. And we have to file the H1B petition before the OPT ends. So if you timely file, if you file before the OPT ends, and if you select a change of status, and if they're invalid OPT, then they qualify for the H1B cap gap. This is in the regulations, and it allows the person to continue to work. Even though their EAD has expired, they can continue to work until their H1B becomes effective on 10/1. A couple of additional considerations with this. First of all, if they qualify for cap gap, let us know. We'll be in touch with you as well, but let us know, and we'll send communication about this. But they should have their I-20, that's the document that the school issues, they should have their I-20 updated to reflect that they have the H1B cap gap. But travel considerations, that's always a question. First of all, travel, even now, 2 years into, well, we're about to start year 3 of the pandemic, is very dicey. Please have a conversation with us about travel, because it can be tricky, to say the least. But anyway, if a person wants to travel, it is possible to travel. However, they have to have the H1B petition approved before they travel. So again, if you have an employee who has OPT, or really any employee who wants to travel, please have a conversation with us. We're happy to walk you through it, because the different fact patterns can make it pretty complex as to what their options are. But for somebody who is on OPT, taking advantage of cap gap, the reason they need to have the H1B petition approved before they travel. The reason I say that is if you travel while a change of status request is pending, that change of status will be denied. The petition itself will be approved, but then your potential employee or your employee will have to go back and have the H1B visa stamped, and that's a whole big thing, especially now with COVID. So make sure you communicate with us, and we're happy to walk you through that. In addition, one other thing to be aware of, and again, we send this communication out to clients closer to the time to remind them, is the employment authorization, this cap gap, is only extended through 9/30. So the H1B should take effect October 1st. However, there are plenty of situations where that H1B petition is not approved before October 1st. So you may want to start, if you have somebody in H1B cap using H1B cap gap, you may want to have a conversation in August about potentially upgrading that H1B petition to premium processing. That means you pay an additional fee, $2,500 to the government, and they will make a decision or issue a request for evidence within 15 calendar days. You don't have to, but depending on when their OPT is going to end and if they're using cap gap, that's something you may want to consider. STEM OPT. So these are other classifications. We talked about OPT a minute ago, and what I said about cap gap applies, like I said, whether a person is on the first 12 months of OPT or whether they have the STEM extension. However, if you have a person who has STEM OPT, let's say you just hired them and they have STEM OPT and you think, oh my goodness, this is amazing. This person has this EAD, employment authorization document, that is valid through 2024. We have plenty of time. My recommendation, and again, this is not legal advice, every case is different, but in general, I really recommend that you register for that person now, because their chance of being selected in the lottery is, again, we'll talk about statistics in just a minute, but the chance of being selected in the lottery is not that high. Even if they're a US master's degree holder, it's maybe 1 in 3 at best. So I would not wait until 2024 to register them in the lottery. Do it now, so that at least, and there are things that we can do if they're selected this year and they don't want to use up their OPT, there are things that we can do to delay the start of the H1B. But I would really consider filing now so that you have as many chances as possible to have that person selected in the lottery. If a person is working on CPT, curricular practical training, just beware. There are situations where an individual will use CPT, whether they know it or not, they'll use CPT to work full-time, and that's really not what it's designed for. We've seen some requests for evidence asking for detailed documentation that they're attending school full-time and that the coursework that they're taking actually requires this hands-on experience and that type of thing. That's, again, we always look at the underlying status of our clients, so that's something we'll be in touch with you about if and when we see that, but just beware that that could be a red flag for USCIS. We talked about the change of status. If you file a change of status, meaning if your employee is in the United States in another classification, whether it's H4, F1, if they're on OPT or CPT, J2, we have some individuals on J2, any sort of status in the United States, they can change status. They can mark, we can mark on the form that they are requesting a change of status, but communicate with us about travel, because if they travel while that's pending, the change of status itself will be deemed abandoned and denied. Like I said, the petition would be approved, but then they'll have to go for H1B stamping and they may not be able to get a consular appointment for a while. If they're currently overseas, that's fine. You can sponsor an individual who's overseas, but just know that there are probably going to be visa stamping delays. Consulates are still working at a reduced capacity. Sometimes they're only issuing emergency visas, and there are some workarounds. They're having visa interview waivers now, where an interview is not required in some instances, but it's still tricky. So just be aware if your candidate is overseas, totally fine. We'll help you work through it, but know that there could be a delay with the visa stamping. So last year, when we gave this webinar, I had a whole series of slides, about 4 slides on these regulations that were in play, possibly. They hadn't been implemented yet, but they were going to be implemented, and we talked about timelines and what it all meant. I am so happy to report that those regulations have been struck down. They've been removed from the regulatory agenda, and for now, until and unless we have a different administration, or until rather, of course, we'll have a different president at some point. But for now, they are not part of the picture. So those rules were the Department of Labor wage rule. They were going to recalculate or change the way that they calculate average wages, which would have raised them significantly. Some of you may remember going through that with some extensions or transfers previously. There was a rule for strengthening the H1B non-immigrant visa classification program that was going to impose some additional requirements. And then there was a rule about the wage-based selection system. So they were going to possibly select H1B cases on the lottery based on what the wage level was and select higher wages over lower wages. None of those are in place. They've all been removed from the regulatory agenda. So that's happy news. So what is the implication of this registration system? We're starting year 3 of this H1B registration system, and there are definitely pros and cons to it. The pros, like I said, are cost efficiencies and time efficiencies. You know, we're not spending time and money preparing a petition just for it to be rejected by USCIS. So that's amazing. The downside of it is that there are more petitions. We'll look at numbers in a minute, but USCIS, or not petitions, but registrations. And that could have happened anyway. You know, there are highs and lows. There are different patterns of the number of people seeking H1Bs. but it makes it pretty easy to file a registration. There's a low barrier to entry into the system. $10, is the registration fee. So an employer can pretty easily register, and we're seeing that there are H1B candidates who will seek out multiple H1B employers for them to register them in the H1B lottery system. I get it. I can't say I wouldn't do that if I were in that particular situation, but as an attorney, I really hate it, because then you have one person who's selected through multiple employers, and they can only take one opportunity. So they're taking up multiple spots that another person could have taken advantage of, could have used. That's, I think, a big challenge in the system. And I personally wish it was prohibited. I'm not in charge, so it's not prohibited. It is prohibited for an employer to register the same employee multiple times, and even within a group of companies. So if there's like a holding company and they have subsidiaries, that can be prohibited, but it's not prohibited for an employee, an individual, for a national to seek out multiple employers to sponsor them. Another risk is the danger of registration without analyzing the eligibility for the H1B. Especially employers who are registering on their own, or having attorneys register who just don't look at the case at all. They just say, okay, we're going to register you and then figure it out and see what happens. Again, that has the potential, and it is taking up a spot, potentially taking up a spot if you're selected where you're not eligible. There's no way that this position could be an H1B position, and they're either going to be denied or they don't register at all and they're taking up a spot that could have gone to somebody else. This is not good or bad, but the timelines have changed for the case submission, preparation, and adjudication. It is a little bit not great because of the adjudication timelines. Everything's kind of pushed back. So we're seeing that more cases are not approved before October 1st, before that start date, because we're not filing the cases until the 30 days after April 1st. So anyway, that's not necessarily great. But the timelines have changed. Even last year, I had prospective employers contacting me in March after the registration had closed saying, hey, I want to file an H1B case. They had no idea that the process had changed, and they were shut out from the system. They couldn't proceed that year. So just be aware that the process has changed, especially if you're used to working under the old system. The number of petitions, this is a chart showing the number of petitions that have been received. And as you can see, it definitely has varied over the years. It kind of goes up and down. So 2015, 233,000, 236 down to 199, 190, 201, and then it skyrocketed. In 2020, the first year of the new system, it was 275,000. Last year in 2021, it's years are hard with the COVID situation. They all run together. Anyway, last year in 2021, the number of petitions was close to 300,000. So I think we're really seeing the effects of this low barrier to entering the system. And I think we'll see probably even more petition or registrations this year. That means your chance of being selected in the lottery is, of course, less, even if you have a US master's degree. It used to be, if you have a US master's degree, your chances were like 1 in 2 or better. That's no longer the case. Now, I'd say even for a US master's degree, your chance of being selected is like 1 in 3, 1 in 4, depending on the numbers. So, and that's, I think, why people are trying to register through multiple employers, which is unfortunate, but it is what it is. We're not in charge of the system. So the danger of registering without analysis. There's a risk, like I was saying earlier, that some cases that are registered for the lottery will be selected for beneficiaries who just don't qualify. They just don't have a petition, an occupation that is an H1B occupation, or they don't have the right credentials. And those selections will take the spot of somebody else who was qualified. And I think that this issue and the issue of employees registering with multiple employers is why we're seeing these multiple rounds of selections. Like I said a few minutes ago, that we had notifications in July and then again in November. And I think that's why, because there's so many people who either didn't qualify and the petition was denied, or they didn't choose to file, or and I think this is more the case, that employees were registering with multiple employers and they could only pursue one. So those other slots went unused. So what is the timeline moving forward? Right now is the time to get things started. It's February. The registration, like I said, opens February 1st. Right now, we are able to gather the information that we need. We would love to have registrations done as early in the process as we can, earlier in March rather than later. We're happy to add cases if they come up last minute. But we'd like to have everything prepared and ready to go so we can get everything done. So this is the time to notify us if you have cases that you would like to proceed with. We're in the process right now of contacting our current corporate clients to gather the information that we need to begin that process. If you have never filed an H1B case before through this registration system, we can create your account in February. So that's something we can do now to get ready. Then, like I said, we would register cases between March 1st and 18th. The notification of selection would happen on or before, or they would rather conduct the lottery on or before March 30th. We would file cases from April to June and possibly thereafter if there are additional rounds of selections. Then we would have a decision within April to November. So that's a common question that people have is, when am I going to know if my petition was approved? And the answer is, it depends, of course. It depends on if you use premium processing. Like I said, if you use premium processing, USCIS will approve the case or issue a request for evidence within 15 calendar days. Even if you don't use premium processing, there's always going to be some cases that they get to first. There's going to be one or multiple ones that are at the top of the stack. So it's possible you would have a decision in April or May or June, even if you don't use premium processing, but it's not guaranteed. And like I said, we have had cases that have been pending beyond October into November, December. So what can we do for you? We can help with your pre-registration analysis. So we can help you review the beneficiary's educational background, review the requirements for the occupation and for your particular position, and make sure that it's a case, we can never make a guarantee, but we want to make sure that we're registering only for cases that really have a solid chance at being approved. We can help you navigate the electronic registration system, and then of course help you prepare and submit cases and communicate with you throughout the process to make sure that the process goes smoothly. So what are the next steps? First, like I said, we're in the process now of reaching out to employers, existing corporate clients who have registered previously, and gathering the information that we need from them. So if you are a new client, a new corporate client, set a time to speak with us. I'm happy to speak with you about the process and get a sense of how we could help you. The next step would be to retain us for the initial case analysis and the registration. And then, like I said, if you're an existing client, if you have questions, we're happy to speak to you, and we'll definitely be in communication with you if we have not already. That is the information that I have. If you all have any questions, feel free to put those in the chat now, or you can email us, and we're happy to help. In the meantime, other ways to stay updated on cutting edge changes in immigration law, which are happening all the time for better or for worse, are to read our blog posts that we update regularly on our website, to join our email newsletter list. We send those the first Wednesday of every month, and to RSVP to future webinars. You can also follow us on social media. We're on LinkedIn, YouTube, Facebook, and Instagram. We have most of our employment-based content on all those platforms, but really on Instagram and YouTube. I mean, LinkedIn and YouTube. I saw the I on LinkedIn and YouTube. So if there are no other questions, I will wrap it up now, but I hope that everyone found this helpful. And like I said, feel free to contact us with any additional questions that you might have. Thank you so much.